My name is Danica Comstock, and I am with the Ada County Public Defender's Office. Can everyone hear me okay? No? Maybe I've got to move it up a little higher. That's better? All right. Good. Well, I have been a public defender with Ada County for 13 years. I'm their Chief Administrative Deputy. We have a Chief Administrative Deputy, a Chief Criminal Deputy, an Assistant Criminal Deputy, and our Chief Public Defender, who's Tony Geddes. Our office is one that provides legal services to individuals who are found not to be able to afford an attorney. We are appointed by the court, so unfortunately you can't just walk into our office and ask us to help you. A judge has to say that we are in fact your assigned attorney. And that usually happens at arraignment, which is one of the hearings that Scott Bandy talked about earlier and some of the other people. So it'll be your video arraignment. Usually you're in custody, but sometimes you're out of custody. And you'll fill out an application for a public defender, and the judge will determine if we are appointed or not, depending on your income level. We represent in criminal matters, we represent in child protection matters, which are situations where the state is attempting to take away perhaps parental rights of parents, and we actually represent the parents. We represent juveniles that are charged with crimes, contempt matters we also appear on, and we handle mental commitment hearings. So we have an assigned mental commitment attorney who handles all of those every day, and unfortunately, every day there are more and more of those. Craig Cannon is our assigned attorney, and he is fantastic with those, working on getting people out that have cleared, or if there's an issue with the commitment process itself. And as the footnote indicates, we are real lawyers. We all went to law school. A lot of us are very, very experienced. I'm going on 19 years as a public defender, having handled felony cases, juvenile cases, misdemeanor cases, homicide cases, you name it, I've probably handled it. And occasionally you might see me on one of those court TV shows if you're lucky. Our office prides ourselves in our zealous advocacy of our clients in providing the best representation we possibly can. Our office has 65 attorneys in it. We have 9 investigators who help us investigate the cases. If our clients have witnesses we need to talk to, other witnesses that we need to track down, they're super helpful for us in preparing the cases for trial or for motion practice or whatever the issue might be. We meet with our clients as soon as we can. Sometimes the hardest issue is tracking them down if they're out of custody. But if they call us, we'll certainly meet with them, talk to them. If there's a language issue, we'll call the trial court administrator's office and have an interpreter meet with us and our clients so that we can communicate in an effective and clear way. Those interpreters are also available for the court hearings as well, but we often need them in our offices to be able to translate discovery, which is always written in English, talk about complex legal issues, which are really, really hard sometimes to translate with the cultural barriers, but we do our very best to explain what's happening and why it's happening and what people's options are. As I indicated before, really our number one priority is to our client, and we have what's called attorney-client privilege. We can't disclose things that our client has said to us unless they've authorized us to disclose that information. This is one of the reasons why sometimes I'll have someone's mom call, and my client's an adult, and I can't tell mom what's going on with my client's case. And part of that is that privileged communication. Part of it is their son is an adult, and he's my client, and mom's not. So I'm going to spend my time with mom and explaining to her, or I'm going to spend the time with my client, not his mom, explaining to him what the issues are, what the process is, what his options are, and really focus on the client. Our clients have access to all their discovery that we're able to provide pursuant to court rules. They can't have access to our personal work product notes, but they should have access to all their discovery that we're authorized to give them. An uninterested party in the case can't come in and ask for our police reports. We won't give it to them. Again, we have a privilege that extends between us and our client, and we're not authorized to release those materials. So if mom comes in demanding discovery in her son's case, we're not going to hand it over. We do have a general online inquiries page. Again, we are only appointed if the court orders appointment, but we do have some information on our general web page through Ada County if you want some more information on the public defender's office. As I've indicated before, we're a pretty large office at this point. When I started 13 years ago, we had 30 attorneys. We now have 65. As I indicated earlier as well, we have 9 investigators, a social worker, and then support staff. So we have about a total of 100 employees at our office, all aimed at helping our clients and helping them navigate the court system once we're appointed by the court. In terms of language access, I've already mentioned this previously, but we typically contact the trial court administrator's office when we need an interpreter, as soon as we're aware that we need an interpreter, and that way we can assure that our client understands what's happening, especially with these complicated legal concepts and issues. And last but not least, these important decisions that our clients make regarding their cases aren't made based on how I think that the client should proceed. Those decisions are made on what the client wants. The client is the one that has the right to a trial. The client is the one that has the right to plead guilty. They're the ones that make those decisions. It's not the lawyers. And we're really sensitive to that because those are their constitutional rights. And we are really focused on protecting those constitutional rights, making sure that our clients are fully informed and advised and aware of the choices that they have to make in the criminal justice system and what's available to them. That was pretty quick. Are there any questions? I'm getting off easy here. All right, thank you.
Hang on, I'm not gonna let you off the hook that easy.
Oh, man.
What if there's somebody who's like limited English proficient and they want somebody to be able to be in the room with, like, maybe in a meeting with their public defender to be able to like look over all those documents with them?
That's not an interpreter?
It's not an interpreter. Maybe it's a case manager, peer support, maybe it's a friend, maybe it's a family member. Would that be allowed?
Depends on the case. Depends on the situation. As a practitioner, I have run into issues with those individuals being in the room because they tend to provide legal advice, which is not accurate. And so my preference typically is to meet with the client and an interpreter to explain the discovery and the criminal process to them. If necessary, we could bring someone else in if it's needed. But what happens when you bring that person into the room is they effectively become a witness in the case. And so you're creating witnesses. That attorney-client privilege bond has been broken. And so that's why we're really, really protective about who's in the room. My personal experience has been that individuals who are not trained attorneys tend to then turn around and give advice that's not accurate or very good advice.
Thank you. I have one more.
Okay.
Because I had this question to me several times over the last 2 years. What if they haven't been able to get a hold of their public defender? They've called the office of messages. Are they going to be able to talk to their public defender like before their court hearing or things like that? Like for their just preliminary?
I have 2 responses to that. Our attorneys are very good about returning phone calls. I get this all the time. I've been trying to call you. I'm like, tell them to leave a message if they've been calling their public defender. We used to be able to meet in the courtrooms and be able to talk to their attorneys prior to court. With WebEx, sometimes we can do a breakout room, but it's very, very difficult to talk to your attorney on the day of court. You really need to meet with them and talk to them prior to court. It's almost impossible to do it now on the video court process. It also depends on the nature of the case. A misdemeanor is a lot easier to talk about, you know, a driving without privileges type of situation or case versus a felony domestic case. There's just a lot to talk about in a felony case. There are a lot of penalties, there are immigration consequences, there's a lot more discovery to go over. There are immigration consequences really, a lot of cases, even misdemeanor cases, and that's something that we also have to review with our clients, and we have to seek the consult of an immigration attorney as well. So my advice is to call your attorney early and often and leave a phone message, because if you don't leave a message, we don't know you called and we can't call you back.
Great, thank you. Does anybody else have any other questions?
Do you guys use the courthouse interpreters?
Mm-hmm. Yes. Sometimes we'll use the language line. Sometimes, you know, as they said earlier, they don't have very many interpreters available, and sometimes it's just the language line, which is a little bit harder, but they're really, really good about providing interpreters when we need them for attorney visits. Even if our clients are at the jail, we can still make that happen, and it makes things go a lot easier.
All right, thank you very much.